Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, let's unpack a recent patent case that has some really interesting takeaways for anyone navigating innovation and IP in India. This deep dive is specifically for you, focusing on a legal challenge to a carbon capture invention, one that made its way to the Madras High Court. We're going to pull the key insights straight from the source material you've shared so you get the essentials without wading through all the legal jargon.
Exactly. We're looking at High Court case CMAPT 2020-24. The judgment itself came down on March 4, 2025. The parties involved: Dr. Vadakkan Thomas, the appellant, he's the inventor fighting the decision, and the respondent is the Assistant Controller of Patents and Designs, basically the Patent Office.
And the core issue, the heart of the dispute, it's about the Patent Office rejecting patent application number 20194104241. The invention was titled A Method for Capturing Carbon Dioxide. Simple enough title, but the rejection led to this appeal.
Right. And just to give you a quick sense of the timeline here, the application was filed, then the first examination report, or FER, came out in December 2021. That's where the Patent Office first raised objections.
What kind of objections?
Primarily two things: lack of inventive step, meaning they thought it was obvious, and an issue under Section 3 of the Patents Act. That section requires showing a clear technical advance or economic edge for certain kinds of inventions.
Pretty standard hurdles in patent prosecution, right?
Very common, yes. So the inventor replied to that FER in June 2022. A hearing followed in October 2023, then some post-hearing submissions. But ultimately, the Patent Office issued the formal rejection order in January 2024.
And that triggered the appeal to the High Court.
Precisely, under Section 117A(2)(a) of the Act, which brings us to the High Court's judgment this past March.
So our mission in this deep dive is to figure out why. Why did the Madras High Court look at that rejection and essentially say, hang on, let's reconsider this? We need to get into the invention itself, the prior art cited, the back and forth arguments, and crucially, the legal thinking the court applied that resulted in sending it back.
Okay, let's zoom in on the invention first. Based on your sources, it's called A Method for Capturing Carbon Dioxide. The key thing the inventor claimed makes it different is that it's a single-stage process.
Single stage.
Yeah, and importantly, it uses an insoluble system. Think alkali or alkaline earth metal carbonates, mixed with an organic solvent and just a bit of water.
Insoluble. So unlike other methods where CO2 might dissolve first, here it precipitates out or something makes it easier to separate.
That's exactly the benefit they highlighted. Because it forms something insoluble, you can apparently just filter it out. Simple separation. The process details mention contacting CO2 with this mix between -50 and 100 degrees Celsius with a specific molar ratio.
And the claimed advantages. Why did the inventor think this was patent-worthy?
They argued it was simple, inexpensive, and offered real economic benefits compared to existing technologies.
Okay, that's the inventor's pitch. How did the Patent Office see it? What were their main reasons for rejecting it initially?
Well, like we said, the big one was lack of inventive step or obviousness. They pointed to 3 other documents prior art called D1, D2, and D3, and basically said anyone skilled in this area could have come up with this invention based on what's in D1, D2, and D3.
They thought it was just a small step, not a real inventive leap.
Pretty much. They also stuck to the Section 3 objection, saying the inventor hadn't really proved any significant technical advance or economic advantage over what was already known.
Did they get specific about why D1, D2, and D3 made it obvious?
Their order mentioned things like mere changes, suggesting switching solvents wasn't inventive without some kind of unexpected or clearly better result. And they pointed out a lack of data, like no specific figures on how much CO2 was captured, and crucially, no side-by-side comparisons showing the organic solvent system was actually technically superior to, say, standard water-based methods.
So a lack of hard proof and a feeling it was just combining known elements. Dr. Thomas, the inventor, obviously disagreed. What were the core arguments his team made to the court?
They really hammered on the differences between their invention and the prior art. They argued D1 and D2 were fundamentally different because those described two-stage processes.
2 stages? How so?
Those methods apparently started with a soluble system where the CO2 dissolved first, meaning you then needed a second stage to get the CO2 back out or separate it. Their invention, they kept stressing, was this unique single-stage insoluble system.
So a completely different process flow, not just tweaking a variable.
That was their argument. They also noted D1 was for specific industrial uses like cement plants. D2 was maybe broader, but the underlying mechanism was the key difference. And D3. They said it wasn't relevant at all because it used totally different chemicals, amine compounds, not their metal carbonate system.
Okay, and this distinction ties into that key patent law concept.
Yes, the teaching, suggestion, or motivation test, or TSM. They argued that even if D1, D2, and D3 existed, there was nothing in them, no clue or hint, that would have motivated a skilled person to combine elements in just the right way to arrive at their specific single-stage insoluble process.
Right, it's not enough for the pieces to exist. There has to be a reason someone would put them together like that, like finding breadcrumbs leading to the invention.
That's a great way to put it. No breadcrumbs, they argued. And then there was a major procedural fight. The Patent Office, in its response to the court during the appeal, suddenly brought up a new reason for rejection.
A new reason, after the initial rejection.
Yes. They tried to compare the invention to an earlier patent that Dr. Thomas himself had already been granted, patent number 201-941-010-Re76.
Wait a minute, they didn't raise that during the examination? Or the hearing?
Nope. The inventor's lawyers strongly objected, saying this was totally unfair. It wasn't in the FER, wasn't in the hearing notice, wasn't even mentioned in the final rejection order they were appealing. Basic procedural fairness violation, they argued.
That does sound like changing the rules mid-game. What else did the inventor argue?
They circled back to the advantages, reiterating that the process is simple, it is inexpensive, it does offer economic benefits, pointing to examples within their patent application. And they contended the Patent Office just hadn't duly considered these points.
Okay, so a strong pushback on both technical grounds and procedural fairness. How did the Patent Office respond in court? Did they back down on anything?
Not really, based on the sources. Their counter-arguments largely repeated the original rejection reasons. They doubled down on the invention being obvious from D1, D2, and D3. They reiterated the claim that the inventor hadn't provided enough solid data-specific results, comparative results to prove technical or economic superiority or any unexpected effects.
And they persisted with that new comparison.
Yes, their counter-affidavit to the court did include that argument, comparing the current application to the inventor's earlier granted patent, trying to use it as further evidence that this new one wasn't inventive enough.
All right, so the High Court had a plateful. Was it obvious? Did the inventor show an advantage? Was the process fair, especially regarding that new ground? What were the key legal questions the court really had to grapple with?
Essentially, yes. 1, did the Patent Office get the obviousness call right based on D1, D2, D3, considering that teaching, suggestion, motivation standard? 2, did they properly evaluate the technical or economic advantage claims under Section 3.2? 3, was it okay to even look at that new argument about the earlier patent, raised so late? And 4, what's the right thing to do now?
Let's dive into the court's thinking. How did they analyze the inventive step, the obviousness question?
The court looked closely. They compared the inventor's single-stage, insoluble system with the two-stage, soluble systems in D1 and D2. They specifically noted that D1, D2 involved a, quote, more complex two-stage process for the segregation of the CO2. And D3, they agreed, used different chemistry amines.
So they acknowledged the differences. What was their conclusion on obviousness?
This is really important. The court explicitly stated that a person skilled in the art would not arrive at the claimed invention on the basis of the cited prior arts. Why? Because, and they used this specific phrase, there were no cues or pointers in D1, D2, or D3 that would lead someone to the inventor's specific approach.
No breadcrumbs, essentially. The court agreed with the inventor on that.
Exactly. It sets a benchmark. Just because prior art exists doesn't make something obvious unless there's a clear reason or hint suggesting the combination or modification.
Okay, so score 1 for the inventor on inventive step. What about Section 3, the technical or economic advantage?
Here, the court found that the Patent Office had not duly considered the inventor's arguments and evidence regarding simplicity, cost, and economic benefits. The implication was that the rejection order just stated the inventor failed, without properly analyzing why or engaging with materials submitted.
So a failure of process by the examiner again, not looking closely enough.
It seems that way. The court felt the conclusion wasn't supported by a thorough assessment.
And the big procedural foul that new ground introduced during the appeal.
Oh, the court was crystal clear on that.
Yeah.
They ruled unequivocally that the new ground, the comparison with the earlier patent raised in the counter affidavit, cannot be considered in course of this appeal. Full stop.
Why not?
Simple procedural fairness. It wasn't raised in the FER, wasn't in the hearing notice, wasn't discussed in the rejection order. You can't ambush the appellant with new arguments at the appeal stage. It fundamentally violates their right to know the case against them and respond appropriately during the examination.
Really reinforces the need to stick to the process. Did they cite any precedents?
Yes, they did. They leaned on their own previous judgment, Rhodia Operations v. Assistant Controller Patents and Designs. Interestingly, the inventor's lawyer had also cited that same case, particularly on the issue of not allowing new grounds late in the day. The inventor also cited a well-known UK case, Windsurfing International, which deals with how to assess obviousness from the skilled person's perspective.
So precedent supported their stance on both the procedural issue and the inventive step analysis. Given all that, what was the final decision?
The High Court decided to set aside the Patent Office's rejection order from January 2024.
Set aside, so wipe the slate clean on that rejection, but they didn't just say, grant the patent, right? What happened next?
No, they didn't grant it directly. They remanded the case.
Remanded sent it back downstairs to the Patent Office for another look.
Correct. But crucially, they sent it back with very specific, detailed instructions on how to conduct that reconsideration.
Ah, okay. What were those instructions? This seems critical.
Extremely critical. First, the Patent Office must now specifically examine whether the invention demonstrates that technical advance or economic advantage. And here's the twist. They must include in this fresh examination a comparison with the inventor's earlier granted patent, that very same patent the Patent Office tried to improperly introduce during the appeal.
Oh, interesting. So the court is saying, okay, that comparison might be relevant, but you have to consider it properly now as part of the reexamination, not as a surprise attack.
Precisely. It has to be done within the proper procedural framework. And linked to that, the inventor must be given a reasonable opportunity to present their case specifically on how their current invention compares to that earlier patent.
Giving them a fair chance to argue the differences this time.
Exactly. And then comes maybe the most significant instruction.
Which is?
The court ordered that this entire reconsideration must be done by a different officer at the Patent Office. Someone other than the officer who issued the original rejection.
Wow. A different officer. Why?
The court stated it explicitly, in order to preclude the possibility of predetermination. They wanted to ensure a truly fresh look, free from any potential bias or inclination to just uphold the previous decision. It's a strong move towards ensuring natural justice.
That really underscores the court's concern about fairness in the process. And was there a deadline?
Yes. The court directed the Patent Office to issue a new, reasoned order within 4 months of receiving the judgment.
Okay, so this ruling isn't just about this one specific invention. It seems to have broader significance. What's the precedential value here?
Well, first, within the Madras High Court's jurisdiction, Tamil Nadu and Pucheri, this decision is binding. That means lower courts, tribunals, and importantly, the Patent Office examiners operating there have to follow it. For other high courts in India, it's persuasive authority. They'll likely take note of the reasoning.
And what specific precedents does it set or reinforce for patent practice?
Several key things. It strongly reinforces the rule against introducing new grounds for rejection during an appeal. Procedural fairness is paramount. It provides concrete guidance on assessing inventive step, emphasizing that lack of cues or pointers in prior art points away from obviousness. It highlights the need for examiners to genuinely engage with and evaluate claims of technical or economic advantage under Section 3D.
And the requirement for a different officer.
That sets a potentially significant precedent for ensuring impartiality when matters are remanded. It's a clear signal that courts want to see a genuinely fresh perspective applied in reconsiderations, avoiding any hint of bias.
All right, let's tie this back to you, the listener. Why should you care about the intricacies of this carbon capture patent case?
Because it's a fantastic window into how the legal system acts as a check on administrative agencies like the Patent Office. It shows you the safeguards in place or being reinforced to ensure inventors get a fair shot and their applications are reviewed rigorously against the actual legal standards.
It makes concepts like inventive step and procedural fairness much more concrete. You see how proving non-obviousness isn't just about being different, but about showing there wasn't a clear path laid out in existing knowledge. And it underlines that if you claim benefits, the system is supposed to actually assess them, not just dismiss them lightly.
Yeah, this case really illustrates the constant balancing act the patent system performs, trying to spur real innovation by rewarding genuine inventive leaps, while also ensuring that knowledge that should be public isn't improperly locked up by patents on obvious ideas.
Absolutely. And the message from the court seems pretty clear, especially for examiners. Follow the procedure, provide solid reasoning based on the evidence and arguments presented, especially for inventive step and Section 3 the, and don't introduce curveballs late in the process. For inventors and those advising them, it's a reminder that meticulously distinguishing your work, backing up your claims of advantage, and knowing your procedural rights are all crucial battles that sometimes, as here, have to be won in court.
So thinking about all this, the court's detailed scrutiny, the emphasis on fairness, the specific tests for invention, what really stands out to you about how these legal frameworks ultimately shape the landscape for innovation?